I'm going to do, folks, if it's okay with everybody, is just put you all on mute while I sort of set the scene and spend a few minutes talking about the event, etc. And then at roughly 10 past, quarter past the hour, I'm then going to pass over to our keynote speaker, Jerry Schlichter. I can't begin to tell you all how pleased I am that we have an opportunity here to listen to an absolute master in this particular space, a man that I and many others have been following for quite some time. So, Jerry, it's really fantastic that you've enabled us to put this event on today. Thank you. Well, where I'm going to start is actually to remind everybody what the Transparency Task Force is all about, because everything we do, we are doing with a sense of purpose. Yeah. So the Transparency Task Force is an international collaborative community for people who want to play an active part in helping to positively reform the way the financial system works. Our mission is very clear. It's very, very clear. Our mission is to promote the ongoing reform of the financial services sector so that it serves society better. And we've quite literally spent 4 years crafting and honing and finessing exactly what our purpose is. I think we've now landed at a place which is absolutely first class. Our mission is to promote ongoing reform of the financial services sector so that it serves society better. Our vision, in other words, what we're planning or hoping to build, is spectacularly ambitious. And it may well be something that we never get to do, but we're going to get as close to our vision as we possibly can. Our vision is to build a highly respected, and those two words are very, very, very important for me and very, very important for the people within our community. Our mission, forgive me, our vision is to build a highly respected international community that is dedicated to protecting the consumer from harm. And that's obviously a theme that is very, very consistent to what this evening's session is all about. I'm going to be sharing my screen to draw your attention to our book, because there's a particular part within our book that is especially relevant to tonight's session. So I'm going to try and do that now. I hope I can do it reasonably efficiently, so please bear with me, folks, whilst I attempt to share my screen. I think I'm doing it correctly. Great. So this is a web page on our website, which is all about our book. The book's title, as you can see, is Why We Must. That must word is there for a reason. Why we must rebuild trustworthiness and confidence in financial services, and how we can do it. It's a very long web page. I won't go through lots and lots of the detail with you, but what I will do is scroll all the way down to a particular part. And there's a particular part which is all about the contents. You'll see, of course, there are lots of individuals who've been very involved with writing the book. We're extremely proud of it. We really are. And there's a section in the book which is all about protecting the consumer from harm. And one of our attendees tonight, Paul Bates from Bates Barristers, is one of the contributors. Here's the here at number 39 is Paul's section, Economic Accountability and Deterrence. I urge you all, of course, to get the book. If you need to borrow it from me, that's absolutely fine. And you can even have a free version if you've got no money. That's absolutely fine as well. But the section that Paul wrote is all about this idea of creating economic accountability and deterrence. And it's that deterrence word which I think is so meaningful about what we're going to be discussing today. And I'm sure this is going to be a theme that Jerry and Paul and hopefully others will pick up on, the power of litigation to act as a very, very effective deterrent in the system. I'll cover off a couple of quick housekeeping notes. Number one, the session is being recorded. We may well use snippets of this or even the entirety of it in social media land to help raise awareness of the event, which would be a good thing to do. And anything you say, please make sure you mean it, because it's going to be recorded. However, if you say something that you really wish you hadn't said, then just pop my colleague Alexandra Zitkus an email. Alexandra's about to put her email into the chat. so you'll know how to email Alexandra if you need to. And I would encourage you all, please, to engage with social media as effective as you can. Alexandra will also put the Transparency Task Force's Twitter handle into the chat too, which is, for those that may want to know right away, is @TransparencyTF. Okay, that's all the kind of the groundwork done. I'm about to pass over to Jerry. The sensible thing to do, folks, is to make sure that you are in speaker view, and you'll know you are in speaker view if at the top right-hand corner you see the words gallery view. If you see speaker view, you're in gallery view. If you see gallery view, you're in speaker view. And if you are in speaker view, what will happen is you'll have the person speaking occupying most of the screen in front of you. My final point before I pass over to Jerry is very simply this. Many people around the world, including myself, including several people on this session, are hardwired into a huge intergenerational societal problem, which is the pensions crisis. Yeah, the pension crisis is a huge issue in the UK. It's a huge issue in Europe. It's a massive issue in America. People are telling me that some of the state pension funds are kind of going bankrupt. This is a massive, massive problem. I remember many, many years ago being right in the middle of the Brixton riots. I was in the wrong place at the wrong time, and it was extremely scary. And you may well be wondering, what on earth has that got to do with pensions? And I'll tell you exactly what. Even in a pretty damn civilized country like the UK, it is possible for social dynamics to develop in such a way that people may feel totally justified in being angry and in being let down, and to feel as though they've been used by the system. And I can tell you firsthand, it doesn't take very much to get a whole load of people feeling very, very angry and taking to protest, and sometimes protest turns into more than just protest. I'm making this point for a very, very specific reason. We all need, on both sides of the Atlantic and everywhere else, we all absolutely need a pensions and investment system around the world that the public at large can have faith and trust and confidence in. It is mission critical importance for policymakers, politicians and regulators to ensure that the pension system they operate has a good chance, not just a small chance or a fair chance, but a good chance of driving out excellent value for money. And all of us understand the long-term consequences of excessive costs in something like a pension scheme have a horribly corrosive and eroding and undermining effect. So I am making a very deliberate and a very obvious point here. There is a systemic need for pension schemes to drive out good value for money, and the mathematics of compounding interest, etc., 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 mean that that simply cannot happen, will not happen, if the schemes they're involved with have excessively high charges. I'm going to mention Chris Toby just before I pass over to Jerry. Chris Toby and I had some conversations a while back. And in fact, it was Chris's idea that really has inspired the title of the session. Chris Toby made a point to me, which is that, you know what, despite the fact that there are literally hundreds of thousands of regulators out in the world, despite the fact that millions, perhaps even billions of pounds and dollars are being spent on the regulatory framework, Chris basically said, you know what, when all is done, the marginal gain of regulation is pretty minimal. What's actually driving huge positive reform of the system is litigation. Now, there are some people who think litigation isn't a good thing, isn't something which adds value to society. I'm absolutely the opposite. I'm enthusiastic about it. If there's a lever that can be used to help people to get justice, value for money, fair play, if there's a lever that can be used to make sure that the little guy or the little girl gets treated properly by the system, then we should enthusiastically support it. And on that note, I'm going to invite Jerry to please unmute himself. Tell us all about his background, what motivated him to get involved in this particular kind of line of activity, how it all started. Take us all the way back to the beginning, Jerry, because your story is fascinating, and I really want people to understand that it hasn't been a bed of roses all the way through for you. So, Jerry, I am so grateful for you giving up your time to be with us today. Mr. Jerry Schlichter, over to you. Thank you very much.
Thank you, Andy, and welcome to everybody. I don't know all of your backgrounds. I do know a couple of you, Paul Secunda and Chris Toby, and I'm familiar with your work. But when Andy asked me to do this, I readily agreed because his theme and his request that I get into the background of how and why I got involved in this space as a helpful, maybe a helpful way of having a context for litigation in the area of financial abuse, as I'll call it. So as a lawyer, I have always, from the beginning in becoming a lawyer, felt that it's possible to live out your values through the practice of law if you really apply your thinking to how you can do that. And from the days, many years ago, as a Vietnam War protester and marching for civil rights and things of that nature, I've always looked at the practice of law as a tool that can bring about positive events and in the lives of people. And so that's where I came from in being an attorney in the US. In that regard, for many years, I and my office represented people in personal injuries, in civil rights actions for employment discrimination, things of that nature. But about in the period of around 2006 or 7, now about 15 years ago, we began getting more and more questions from our clients who are strictly individuals. We don't represent any corporations or institutional people. And by the way, I founded the law firm that I have in St. Louis in the US now back in the very late 80s, doing this kind of work. Everything I do is on a contingent fee basis, meaning that in the US you can represent people who cannot take on a large corporation, pay an hourly rate to an attorney, as corporations and insurance companies are able to handle. And the key to the courthouse for such folks, ordinary people, you mentioned little people, Andy, is a contingent fee whereby you take on the case on a percentage, you don't charge an hourly rate, and you advance all the costs and expenses, which can be very, very expensive in big cases, with the idea that if your clients win, then you get a percentage of what you get for them and have an incentive to maximize that amount. But if you lose, everything is down the drain. All your time is gone. All the money you advance for expenses for things like expert witnesses and court costs is gone, which means you can't get the money back from your clients because they don't have it. That's the only way I've represented people in my career. So as we have seen in the US, a sea change, and I mean a sea change in the American retirement system from the traditional defined benefit pension plan to the defined contribution model, the 401k model, where you have the employee putting up some money and the employer making a match typically, followed by the shift in risk from the employer no longer needing to meet the amount that's required for the pension, to the risk shifting to the employee whose assets are, or retiree whose assets are now in play and at risk. And that's true if the market goes down or if the market goes up. It also is true if fees are high. So people were asking the question, how do I figure out what's happening in my plan? I don't think I'm going to have enough to retire on, and I'm really not sure what all these fees and charges are. Can you help? Can you look into this? We did that, And we spent in my office a year and 9 months digging deeply into the industry, the financial services industry, and specifically the 401k industry. And I came away with two shocking conclusions. One, despite the fact that in America, as I said, the American retirement system has shifted to the defined contribution model, putting the employee and retirees' money at risk, and the fact that there are 600,000 401k plans in America. It is truly America's retirement system. And the law that's been around for 30 years at that time requires that fees be reasonable and investments be prudent. It's called the Employee Income and Retirement Income Security Act, ERISA. Despite that law, and despite the fact that a participant in a plan, an employee or retiree, can bring an action in court for excessive fees or imprudent investments, in the 30-year history of 401ks and that corresponding 30-year history of the law, ERISA, there had never been a case brought for excessive fees in history. And in addition, a second astonishing fact was the regulator, to your point, Andy, about regulation. The regulator is the Federal Department of Labor, federal government in the US. And the federal government can bring an action against any financial manager, any plan on behalf of the employees and retirees for imprudent investments or excessive fees. Despite that fact, there had never been a case brought by the Department of Labor, by the government, never an enforcement action in the 600,000 plans over 30 years. So what we had in this country is a very opaque, non-transparent arrangement whereby you have employee money with no financial incentive by the employer, nobody's bonus or salaries depending upon what happens in the 401k plan or what the return is, and no litigation and no regulation, none. A side story that hasn't really been covered is the way the government just was on the sidelines for decades in enforcing America's retirement system. So I weighed whether or not to dive into this with litigation. Having been involved in prior so-called bet the farm litigation with much at stake and massive resources, I knew since this area did not even exist, this would be a risky, highly expensive, massively expensive nuclear war. Because without the litigation even being existing, it was clear to me that the companies would fight to the end to try to avoid having a whole new area of litigation on behalf of employees develop. And that's exactly what occurred after I made the very sobering decision to take on the biggest companies in the country on behalf of their employees and retirees. Companies such as Boeing, Lockheed Martin, Caterpillar, Kraft Foods, International Paper, and so on. That required, I knew, so many resources, all of which would have to be advanced by myself and my small law firm. I had two partners, which meant we could not begin to finance this simply out of our own resources. We'd have to get a monster line of credit, 8-figure line of credit. So we put our houses, our net worth, everything on the line. Because without that, we wouldn't have the perseverance to carry the fight for what I knew would be a long period of years. So we did that and filed in 2006 a series of about 12 cases against these very, very large companies, all of which had billion-dollar or multi-billion-dollar plans with tens of thousands of people, some of them having over 100,000 people. Boeing, for example, second biggest plan in America, $26 billion in its employees' 401k plan. In this country, there are about 8 or 9 large insurance companies which insure fiduciary liability coverage. The fiduciaries are the people running the plan. And they have layers of coverage, insurance coverage, for a claim of a fiduciary breach, which is what these claims are about. The leading insurer is AIG. AIG, one of the largest insurance companies in the world, had their top person in New York meet with me and told me, after we file these cases, we will never settle these cases. We will never pay a penny voluntarily. We don't care what we pay to fight the cases. We don't care what we pay to our attorneys, and we will put your firm out of business. Which, speaking of sobering, is extremely sobering. And I can remember my wife asking me in the middle of the night on many occasions, why are you awake? And I said, I'm thinking about what we're doing here. It was very, very spooky, frankly. And even my partners said at a couple of points, maybe we ought to just abandon this. So what happened was we filed these cases all over the United States from coast to coast. And multiple federal judges dismissed the cases early on, saying that essentially, as long as there are choices, it's up to the participant to make the choice of which investments, and that's on them, no case. And those cases, 3 of those cases that were dismissed were upheld when we took appeals to the Court of Appeals, one step below the US Supreme Court. So it was a bleak outlook. We had advanced millions of dollars. And I had a federal judge say to me, have you thought about simply dropping these cases because it looks like the mantra has become they're not of any validity? I said, well, we're going to see it through. I didn't take this on without planning to go all the way wherever that endpoint is and wherever it leads. So these were conservative judges who didn't really want to, in my opinion, drill down into the weeds very much. But we kept at it, and we began to get judges who would look beyond the choices and look at what those fees were. But before that point, one telling indication, speaking of regulation and speaking of the need for more regulation, was after we filed the cases, I got a call from the government, from the Department of Labor in Washington, asking me to come there to explain what we're doing, which I did. And they said these were the top people in charge of enforcing America's retirement system, who had never brought such a case. They said, well, what are some themes that you see that are common to these cases? I said, well, here's one. billion-dollar plans, $1 billion or more in assets, having funds that are retail mutual funds, charging fees that a $500 investor would get, when the requirement is that they have to put themselves in a like position for someone who has that level of assets. Obviously, there are far lower fees that one can obtain from institutional mutual funds or collective accounts or pooled accounts of one kind or another. The reaction when I said that to the regulators, the top people in the United States in charge of regulating America's retirement system, was, we don't see anything wrong with that. What's the problem? Shockingly. Another thing I pointed out is, I said, in these plans, there are record-keeping charges. Every plan has to have somebody taking account of the withdrawals and contributions and so on. And that's a commodity function that has nothing to do with asset size. If you have $100,000 in your account I have $10,000 in mine. It doesn't cost any more to keep track of your balance and send a monthly statement or internet access for you than for me. Yet if you're charging out of the expense ratio of the funds, an asset-based charge, then that charge will go up for record keeping if the market simply goes up, or if you add more to your account for no more services. Again, the reaction, we never thought about that. Don't see a problem there. Fast forward, they now get that. They have been educated through the litigation that we brought. So we continued on, and we got to the point where the very first trial of such a case occurred in 2010 against an international company called ABB, which is a Swiss company that has purchased the assets of Westinghouse. We sued Fidelity in that case as well as the employer because it was a Fidelity retail plan, and we felt that Fidelity was making decisions instead of the employer in its own interest. To give you an idea of the fight and of the resistance, ABB had 2 national law firms with 5 lawyers at their table in the courtroom. Fidelity, whose business model was under attack, had 3 national law firms and 6 lawyers at their table. 9 more lawyers, that's 11 lawyers. 9 more lawyers in the courtroom in the seats in the back for the entirety of a 1-month trial. Massive resources devoted to fighting this. And later on, we learned that they had spent $42 million to pay their lawyers alone. To show you one other example of the uncapped, unlimited expenditure to fight all this, one of the expert witnesses they had, and both sides have to have expert witnesses, was a person who testified about retail funds, and he basically testified that retail funds could not be unreasonably expensive because the market no one would buy them, as if the average retail investor knows what a rate should be for retail mutual funds. That person was Bush's former chairman, President Bush's former chairman of the Council of Economic Advisors, and currently dean of the business school at Columbia University. I asked him, what are you charging for your testimony here? Well, $1,000 an hour, but I actually raised it to $1,200, but I'm keeping it at $1,000 for this case. How many hours do you have? This is proper questioning because it goes to bias. Well, 200. So $200,000 for your testimony here. Anything else? Yes. I get 7.5% of the billings of a research firm that does research for me if I'm an expert witness. Oh, so how much is that? $225,000. So I said, $425,000 for your testimony here? That's about right. And that's 2 hours of testimony. And if the research, if 7.5% of the research firm's charges is $225,000, then doesn't that mean the research firm was getting about, what, $3 million? It's about right. So $3.4 million for one expert's testimony and his research. And they had 6 experts in the case. That's on top of the $42 million they spent to fight it. 1-month trial, we won that case. Sideline note, in the middle, I don't know if I mentioned this to you, Andy, I may have, in the middle of that third day of trial, we see a CNN report that there had been a shooting at the ABB facility in St. Louis. We had in a class action, those of you who don't know that, you have some number of people who bring the case for the whole group. One of those people was from that plant in St. Louis. We called our client to see if he was okay, no answer. I told the attorneys for the company that there had been this shooting on CNN, and everybody scrambled to their cell phones. turns out they said, your client is the suspect in this shooting. And at that point I said, well, he's scheduled to be here in 2 days and he knows the directions to the courthouse, which was in Kansas City. And the judge decided to post the federal marshals outside the courthouse to guard the courthouse. Because I said, he knows the company's lawyers and executives are here. So it turned out later in the day, it turned out he was the shooter. 3 people were killed. Other people were wounded, and he killed himself in the plant. And the only thing that anybody knew was he was very unhappy with the return on his investments. So it was the most bizarre thing that ever happened to me in a courtroom. But we continued with the trial. So we won that case. We had a substantial $36 million judgment, which they then appealed as far as they could and as much as they could. And the whole case ended up only ending last year after 2 appeals, 2 attempts to get to the US Supreme Court, 12 and a half years, carrying 27,000 attorney hours in the case. All of those lawyers were paid every 2 weeks with a paycheck, but we carried that, and massive expenses. That really began to turn the ship around, and it culminated with a case in the United States Supreme Court in 2015, also involving a company called Edison International, big utility in Los Angeles. And that case had retail mutual funds in a $2 billion plan. We asked the US Supreme Court to take that case after the lower courts ruled against us. The court took the case. They don't take very many at all, less than 1%. And we had supporting briefs from the Solicitor General of the United States and the AARP. They had supporting briefs from the mutual fund industry and the National Chamber of Commerce. Everybody agreed it would affect every plan in the country. And I'm pleased that we won that case unanimously with the Supreme Court, 9-0, which does not happen very often with the Supreme Court in our country. That had a major effect. And this, I guess the full circle story is that the AIG guy I mentioned earlier, who said they'd never pay a penny, ultimately got back to me and said, we tried, we failed, we couldn't shut this down. Now this area of litigation exists, and we're going to look at it as any other piece of litigation. So fast forward, now the media have gotten all over this, the mainstream media, the Wall Street Journal, the New York Times, Bloomberg, Reuters, Financial Times, and other publications. And they really get it now. There was no coverage of this in the beginning, but now they really understand it. In addition, in fact, the New York Times called me the Lone Ranger of 401k plans. In addition, the multiple federal judges have said that this litigation has brought down fees in the industry by over $2.2 billion annually, has had a major, major impact on fees throughout the industry, and has caused fiduciaries to look very carefully at their plans because of the potential exposure to litigation. Now we're also seeing that many other firms, Paul here on the call has recently gone into private practice from his work as a law professor at Marquette University, and has actually filed several cases in the last, this year. And other attorneys now, after there were no attorneys who filed similar litigation for years because the cases were not going anywhere. But now they have been, and there are many cases. There's much litigation going on now as we speak. So also federal judges have pointed out that we've educated the Department of Labor, we've educated the regulator, believe it or not, to do their job more effectively. And that's, unfortunately, it had to be done through this war of attrition, this nuclear war, with everything I had on the line and my two partners, instead of the government simply coming in. If they had filed 2 or 3 cases back at the beginning of the 401k plans and put the resources of the government and the imprimatur of the government behind this, no one would have thought, we'll put the government out of business. No one would have said, we're going to have this war of attrition and bury a law firm. It would have made a huge difference for employees and retirees for decades until we initiated this litigation. So it's a profound example of your point, Andy, that litigation has a major role, in particular, where the regulators abandon the role they're supposed to have and are required by law to perform. It's a story about that as much as about anything. For me personally, it's been a gratifying journey and full circle for me also, paying off the debt through settlements and verdicts and judgments in cases, and getting ahead of the debt, and also making a difference in people's lives, which was the ultimate objective I had. If it hadn't been for that goal, looking at this from a strictly financial standpoint as a lawyer, I never would have done it. So that's a history, a long history, I'm sorry for the length, but gives you an idea of the context to where we are now.
Jerry, I'm sure others in this meeting are feeling exactly the way that I am. It's an honor to hear you explain the journey that you've been on. It really is. It really is. You know, it wouldn't surprise me if you personally, you and your team, your small, under-resourced team, have achieved more for the well-being of pension savers in the USA than perhaps anything or anybody else. And you've done it at enormous personal risk. I'm going to ask you one question, if I may, and then I'm going to invite our guests on the session today to ask questions as well. Jerry, and I'm sure this must have been something you'd have thought about. What would have been the consequences for you if you'd lost the first case? What could it have meant? What were you staring down the barrel of a gun at if it had gone the other way?
Devastation, Andy, in a word. It would have been a precedent for other courts, without a doubt. It probably would have been the end of the area of litigation. I'd used up the line of credit entirely. All that debt, 8 figures of debt, was owed at that time. And the line of credit was expired. We didn't have any more resources to commit to getting any more of a line of credit to carry on the litigation. So I think it would have been personally a disaster, resulting in bankruptcy for me and my 2 partners. But more importantly than the impact on us, I think the insurance companies would have accomplished their objective of putting the firm out of business and shutting down the litigation.
Yeah.
And it would have been, I mean, there's a reason that nobody ever took it on, because of that staggering risk. And I would say that it would have been even less likely anybody would do it after the example set by us.
Thank you, Jerry. It's been a sobering story to listen to, let alone to actually live through. You really are an absolute inspiration to everybody that's trying to do something to make the financial services sector behave as we want it to. And I'm repeating myself, I'm honoured that you are giving your time with us today to share your story. What we're going to
Thank you.
do, what we're going to do now, folks, is invite people just to raise or wave their hand, make comments, ask questions. Later on, we're going to have some sort of short speaking slots from Chris Tovey, then Robin Powell, then George Melman, then Philip Miller, then Paul Secunda, then Eric Smith. But before we get to that stage, let's all take the opportunity for those that wish to make comments or put questions to Jerry. I'm sure some folks will want to do that. So just wave if you want to draw attention to me. Mr. Paul Bates, as always, lovely to have you with us. Over to you, Paul. Thank you.
Very well spoken, Jerry. It's inspiring to speak to someone at the other end of that experience, especially as I'm someone at the earlier phase of it, launching about 10 to 12 investment fund claims in Canada relating to things like closet indexing and fees and charges paid out of these funds for distribution commissions that are relied upon to justify excessive management fees. So it's a developing landscape in Canada. Many of the cases are in British Columbia, some are in Ontario, but we have national class scope in either of these provincial courts and Quebec as well. And so it's a developing area here. And the theories are fiduciary liability of investment fund managers primarily. And we'll see how they come out. Our judges are meant to be better than average at case management. They are not. They're reluctant to case manage, and they tend to defer to the big firms from urban financial centers, but not always. Recently, a claim for closet indexing was certified on consent, remarkably, against TD Asset Management in connection with a $2.5 billion fund. And there will be 4 or 5 others of those here, as well as trailers. So great to hear the story. Hopefully it won't last 15 years up here, but maybe it will.
Well, that's interesting, Paul. I can't believe they've, so one of the keys in these cases is getting class certification, you can't bring a case for 3 people for their losses. You can't begin to. You've got to get a class certified, and we've been successful in that. The courts have gone that way, and meaning you bring it on behalf of the entire group of people in the plan, because they're all subject to the same fees and investments. But I'm surprised they stipulated to that, Paul, and maybe it would be worthwhile for you and I to talk offline after this at some point about common issues, and also whether there's any potential for cooperation in any way.
I'd be interested. The 2 legal theories in a sentence are fiduciary liability of the investment fund managers, which is novel here. It's never before been raised. And then the second theory is prospectus misrepresentation, because mutual funds are securities and they're distributed under continuous prospectus rules. But there's a very tight time limit for those claims, and it's very hard to get around it. So I actually prefer the fiduciary theory of investment fund managers. And when you read these declarations of trust one after another, they look attractive. The obligations are there, and also in securities legislation, interestingly, for investment fund managers. So yeah, good thought, Jerry, but very entertaining to hear it. I think I can last 25 years, but I want it to last 10 or less.
Very good. Very good. We're going to go to, thanks for the question, Paul. That's great. And by the way, could I invite everybody to briefly introduce themselves before making your point? And let's do it back to front with Paul. So Paul, people have got the gist of who you are and what you do, but just let everybody know who you are and what you do, please, Paul. Thank you.
I'm a Canadian and UK qualified barrister who's practiced in Canada for just under 40 years in complex commercial litigation, and currently obtaining qualifications in Massachusetts, as a matter of fact.
Thank you, Paul. Fine. So my colleague, Alexandra, who's behind the TTF logo, Alexandra, can you make a note to connect to Jerry with Paul by email so the 2 can pick up the conversation later on? Let's now go to Mr. Henry Tapper, who's got his hand digitally raised. I'm very impressed, Henry. Over to you, sir. You'll need to unmute, please, Henry. Thank you. It's still muted, Henry. So bottom left-hand corner, Henry.
Myself, sorry. Do excuse me. Do excuse me. I thought I was being unmuted. Yeah, my name's Henry Tapper. I've been involved in helping some very vulnerable people in the past, who've had quite a large amount of money taken from them as a result of what we call fractional scamming, which is the practice of overindulgence in fees against people who've got large amounts of money tied up in pensions with very little financial knowledge. The system which is used in order to extract these fees is known in this country as contingent charging, which is ironic because it's precisely the system that you use to protect those vulnerable people. And we've recently, and it will come into effect at the end of this month, achieved a ruling that stops financial advisors subsidizing their fees with tax-advantaged contingent charging. To what extent, my question is this, to what extent is the law in America on the side of the vulnerable person? Because the feeling has been until now that the law in the UK is on the side of the advisor who is perhaps not acting with the best interests of their clients.
Yeah, it's a great question, Henry. The law under which these cases have been brought, the Employee Retirement Income Security Act, has protection and creates this fiduciary liability, which has been described as the highest duty under the law. But the implementation and enforcement of that law is where it gets very gray. We have, well, first of all, the Department of Labor, after all of this, came out with what they called a fiduciary rule proposal several years ago under the prior administration, under the Obama administration, and it was very friendly to employees and retirees. But with the change in administration, that has been killed by the Trump administration. And now there have been proposals for a best interest rule, so-called best interest rule for brokers, that has been a watered down version of that. Also, in our country, federal judges are appointed by the president. And so the ideology and the background of those federal judges makes an enormous, enormous difference in how the law is interpreted and followed. And we see that in our own cases. The swing of difference between one judge and another judge is astronomical. As I said, cases were dismissed that ultimately were similar to that ABB case that went to trial with a very different result. So I think in this country, it's the way in which the law is interpreted. And that has been in many areas pro-corporation, pro-financial services representatives, as opposed to pro-individual in lots of ways over the years. It's the difference between what's on paper and how that paper is in fact applied and interpreted.
Thank you, Henry. Thank you, Jerry. Who'd like to go next with a comment or the question? Just raise a hand if you'd like to go next, please. Mr. Philip Miller. We'll go to Philip and then I'll draw a comment from Robin Powell. Philip, first to you, then to Robin. Thank you.
Thanks, Andy, and thank you very much for that, Jerry. It was enthralling, and I'm glad it ended well, or is still ongoing, obviously, but I'm glad it's going well.
Still going.
So I'm Phil Miller, and I'm co-founder and MD, I guess, of a business called Fair Return. Now, we help retail investors, mainly those who've been badly advised to transfer out of defined benefit schemes into what we call personal pensions over here, get fair compensation for the damage done by that bad advice. And so I've been thinking, Jerry, about this kind of really long struggle that you've been through, and you've talked about how you kind of knew what you were getting into at the outset, but maybe not the extent of where it would get to with this 8-figure line of credit that had been completely used up. And I just want to explain to you briefly a scenario that we have here in the UK for how victims of this financial abuse can get redress, and get your thoughts on what you think about it. So in this country, we have what's called an ADR provider, an alternative dispute resolution provider called the Financial Ombudsman Service. And the key features of that service, and it's meant to be an alternative to the courts, so an alternative to litigation. Retail investors are required to explore that option before they really embark upon litigation. The Financial Ombudsman Service is free to the consumer, entirely free to the consumer, has the power to award up to £350,000 per individual in compensation. It can award compensation for bad advice given as far back as the 1980s, so the time limits that apply in the courts, 6 years, 3 years data knowledge, 15-year long stop, don't apply to the Financial Ombudsman Service. Bad Financial Ombudsman Service decisions can be overturned by judicial review. So instead of having to go up against a big bank or financial institution or insurance company that might spend millions or tens of millions defending it, the FOS may well decide, well, okay, we're not going to bother. It has no financial incentive to engage in what you called a war of attrition in order to try and prove itself right. So if you were starting out now in the UK and that was the business opportunity, and if there were millions of people who'd been victims of this kind of bad advice, how would you rate your chances of succeeding?
Well, I start, Phil, with the concept that there is enormous financial abuse going on as we speak in all forms and all countries. The financial services industry is the most profitable industry in the world. And I guess a principle that I believe is true is the more opaque, the more under the radar financial transactions are, the more people will operate in their own financial interest, not complex. And that's what we see. And it seems to me that that what you're talking about is still one more example of that. I think there's more and more recognition among people throughout the world that this is going on as financial institutions have gotten bigger and bigger and bigger, and people are brushing up against those systems in the ways that you mentioned. Retail investors end up feeling they don't have a voice, they don't have control, they don't understand things, and they don't know where to go with it. That's how we got started. That's why people came to us. And it seems to me the same thing is going on in the UK. Because you've got these massive institutions with massive marketing and prospectuses that are 50 pages long, nobody reads. If you get it online, you check the thing, yes, I read and agree to the conditions. Everybody does that, even lawyers. And so I think one example, we have always wanted jury trials in these cases. And there's a gray area in the law, actually going back to the English common law 800 years ago, distinguishing, and you're shaking your head, Paul, between law and equity. Equity being non-financial matters, law being where you get a monetary compensation. And the courts have interpreted this as equity and not given jury trials. I've longed to have a jury trial in any of these cases. They're all judge trials because we know that juries will get this. They don't have to be sophisticated, they get it. So to answer your question, I think what I would do in the UK is I would use social media, very sophisticated, targeted social media to see about reaching those folks who may have a claim, who may have claims, and seeing whether they pan out when you talk to the people, you investigate what they have, what's gone on. And it may be that there are a whole lot of folks who would be people who may have claims that maybe would have to be handled individually or maybe could be consolidated in some way. As I think the UK is moving somewhat more toward the class action model than had been the case historically.
Well, I can tell you, Jerry, that we do use social media. We advertise on Facebook, and I don't mind saying here that for a relatively minor advertising spend, you know, in the region of £12,500, we've accumulated a pipeline of 240 ongoing cases. You know, and that one number for me says there are so many people out there who are not happy with how they've been treated and want to do something about it.
Have you talked to a barrister or a solicitor about pursuing those cases?
Yeah, I mean, we are pursuing all of them, and there are lots of different types of cases within that pipeline. And Andy and I actually spoke with a QC last week about one category that you know, will take a little bit of work to get a positive result on might be about 20-25 cases, but fit what they call over here the Wensbury unreasonableness test. So if a public body makes a decision that even you know, any reasonable person would deem to be unreasonable, you're likely to succeed at judicial review. And what that means in the context of the Financial Ombudsman Service is that all of the cases that this thing applies to, the Financial Ombudsman Service would have to start would have to change how it makes decisions based on that judicial review. So I guess the point of the question was that, you know, what you've accomplished over there in the States was in the face of enormously challenging opposition, well-resourced opposition. Those numbers you told me about the trial with, you know, 20 judges and 42 million in legal fees, and over here you could probably commit, you know, a 5-figure sum to a judicial review, and the number of people that would impact would be measured in the tens of thousands, each owed a 5-figure sum, you know, on average. It's quite a, I always think if they had a Financial Ombudsman Service in the States, lawyers would have realized long ago just what the potential is for making that organization do the right thing.
Yeah, I would be interested in also your contact information.
Yeah, sure. So, Alexandra, can we please fix up a call with Jerry and Philip? And one of the things that Philip and I spoke about not too long ago was the general dynamic, and this is a very, very general point, that the general dynamic that the political and policy making and regulatory framework, the default position is to protect the status quo, to protect the establishment, to protect the power base. One of the individuals within our community is absolutely convinced that we'll never really have societies that are being looked after properly by their governments until we have governments that are elected without a dependency on huge donations from particular parts of the system. And that is perhaps the very fountainhead where a lot of these root issues come from, because if we had true democracy where the little guy's vote really counted, as opposed to the votes of a very small percentage of people who had access to huge power and huge influence, we would find ourselves in societies that didn't have to fight and run the risk of, you know, 10-figure debt to try to bring about justice. It's a hugely interesting point. Thank you for your comment, Philip, and your response, Jerry. Let's go to Robin Powell. I think it may well have been Robin that was the very first person to actually tell me about Jerry in the first place. It wouldn't surprise me. Robin, please introduce yourself and share your thoughts. Thank you.
Well, I'm Robin Powell. I'm a freelance journalist. I founded the investment blog, The Evidence-Based Investor. I'm a marketing and content consultant for, without being too pompous about it, you know, the good guys in the investing industry. Thank you, Jerry, for sharing your wisdom today and the excellent work that you're doing in the US. You know, your story is truly inspirational. I'm looking at the list of the organizations who you've successfully taken to court You know, these are highly respected, huge multinational businesses. There are universities in there. And you know, it just begs the question, what were the trustees, what were the plan sponsors thinking of? I mean, why didn't they question the advice given and the fees that they were charged? And do you think it's a simple lack of knowledge that's the problem? Or, you know, are there other, perhaps more ethical issues at play here? What do you make of the standard of trustees? And do you see a bigger role for trustee education?
Absolutely. Rob and I look at two categories of activity. One is what I'll call asleep at the switch, so to speak, not really knowing or caring about what they should care about. And the other is outright self-dealing, which is in a minority of cases, but is very much something that has occurred. As to the first, again, the context was that the people who are put in charge of the trustees, the fiduciaries in these plans were typically human resources people, maybe they have a financial background, but they're put on a committee. They would typically review quarterly what's going on in the plan. We saw cases where people set their, they set the meetings at 4:30 on a Friday afternoon. Everybody's checking their watch to get out of there. And there's not any level of scrutiny because there's no financial incentive. The people on the committee aren't paid for what they do. Their bonus, their salary is not dependent on how the plan performs. And the company's bottom line is not affected by the performance of the plan. All that risk is on the employee and the retiree. And then with no body, and I don't mean nobody, I mean no body such as a governmental body or and no litigation, it was opaque. People were simply asleep at the switch, not caring particularly, and the financial services industry in this country figured out that there was an explosion of assets, $5 trillion now in defined contribution plans, and wanted to and did jump into that space. And the problem is they're not fiduciaries, they're not trustees. So they come in and market their own products. Fidelity comes in and says, hey, we've got great retail mutual funds, put those in your plan. And by the way, we'll take you out to dinner and give you some baseball tickets or football or soccer, whatever, if you do this. And nobody's minding the store, nobody's watching that. So the financial services industry, I was struck early on in this process. I talked to, and by the way, finding people who are experts and who would be willing to take on some of this was not easy because so many of them had a vested interest. But one fellow told me, he said, when I've been involved since these 401k plans started, and at the annual seminars in the industry, we had employers who came in and talked about what they're doing. But gradually we saw the financial services people take over, and they're not fiduciaries. They're making as much money as they can. The fiduciaries need to control them, and they don't. So that's what's happened in some cases. In other cases, the self-dealing I mentioned, I'll give you an example. In the ABB case, Fidelity came in and said in a plan for which the employer was being charged, was paying the record keeping fees, how would you like to have a free plan? Won't cost you a penny for record keeping. Great, where do we sign up? Well, here's all you do. Put in your plan, a bunch of our Fidelity retail mutual funds, though it's $1 billion plan, and then we'll, through the expense ratio, say 100 basis points, we'll take 25 basis points of revenue sharing, give that to our in-house record keeper, and then the employees will be paying the record keeping. Oh, okay. And then what they did is they used Fidelity for their own executives pension plan and their payroll processing and their health and welfare plan, all of which were on employer money, charging the employer, and all of which were furnished at a loss to Fidelity, Meanwhile, the 401k plan, where the employee's money was at risk, they were getting more than a 50% profit. So what we had was the employees subsidizing corporate expenses through their own retirement assets, a blatant self-dealing. So I think the major problem is that these people simply didn't care and didn't have anyone checking on their activity and simply mailed it in.
Yeah, thank you.
Thank you, Jerry, and thanks for your question there, Robin. A great question. Eric, did you raise your hand just then? Did I see a hand go up, Eric? Yes, please. Eric Smith, please introduce yourself. Off you go. Take off the mute, please, and tell us all a bit about yourself, Eric, and make your point. Thank you.
Hi, everyone. I am a recovering attorney. I practiced for 22 years in estate planning, corporate business transactions, and ERISA, and actually got started shortly after ERISA was adopted. So I've had a long time to view the area. A couple of things. One of the key things that you mentioned, Jerry, and I'm a big fan of your work, is the asleep at the switch. And I would like to add this to that, and that is, it's not simply being asleep at the switch, it's not being aware of where the switch is, because you're, in most cases, as was pointed out by a district judge in your Tibble versus Edison case, the trustees are claimed that they were relying on the advice of a single investment consultant. And that seems to be the general case everywhere in the country. If they have an investment consultant at all, they only have one. And therefore, the advice that the trustees are getting, which, as you correctly point out, are typically not experienced in the financial services world, are getting advice that they have no way to vet. And so I would submit to you that that's one of the issues, that yes, they're a fiduciary, but they're sitting there and getting advice with no practical way to vet any of the advice that they're given. So education is a key, but I wanted your comment on that. And also I'd like to know how in the beginning you were sourcing the cases, because you don't have a case unless you've got a representative, plaintiff in there that's subjected to the harm. And a lot of the times the employees have no way to even tell that they're being harmed, or to the extent. So I was interested in both those things.
Yes, Eric, as to the first, education, and this goes back to your question, Robin, I think education of the trustees is of vital importance. And now, again, because of the litigation, that's one thing that's also happening, because a lack of education can be brought out in these cases. If you're not having ongoing training and ongoing advice, then that by itself could be a fiduciary breach. So with the background of litigation, there's much more of an education process going on by fiduciaries and trustees. And that's a good thing for for workers and retirees. As to the second point you asked about, where do you get the clients? That's a question that's very good question. That was not easy at all. In the beginning days, the prevalence and the segmentation of social media like Facebook, where you can now actually get so many, people who read Barron's, people who work for a certain employer, and many other segmentations, that wasn't so prevalent. So we had a very hard time finding people who would talk to us about their plan. We looked at some of these big plans that we thought were potentially a problem from some publicly available information that was sketchy. But to really determine what's going on, we had to talk to people and get their communications from the company. How do you do that? Well, what we did was we actually looked at where employees of certain companies were in large facilities, a concentration of employees. And then what we did is we did print ads in local small town newspapers and not big papers that were very expensive, saying we're investigating the, say, the Boeing plan, and we'd like to talk to you if you're an employee or retiree. It was not easy to get people to talk to us. They were scared, even though ERISA, the law, protects them. They were worried about employer retaliation, didn't want to come forward. They're talking to somebody they don't know. So we would go out and meet with them. And I'd say rule of thumb was for those who answered, who called in response to an ad, maybe 1 out of 10 would agree to meet. And then of those who agreed to meet, we'd fly to their town or their city. Of those who agreed to meet, maybe 1 out of 8 or 9 would agree to be a named plaintiff in the case. So there was a tremendous amount of challenge in getting people to speak up. But there were people who really wanted to work for the betterment of all the employees and took pride in being in that role. And to their credit, stayed with it. I'll tell you another thing that happened that affected this. In the John Deere case, one of those early cases I mentioned that was dismissed, and I haven't mentioned this to you, Andy. Judge dismissed the case, said no case, retail mutual funds, the woman in charge, the lead fiduciary had a high school education, had not gone to a college or university, didn't know what was going on in the world. She was a human resources assistant manager. Fidelity came in, flew her to Boston, took her to a hockey game, got her some seafood, and said, put our Fidelity investments in your plan, all retail, which she did. And the judge said, no case. And the Court of Appeals upheld that, no case. And the Supreme Court wouldn't take it. So we lost. They then got an order from the court assessing $225,000 in expenses against these 3 named plaintiffs who brought the case, including a woman who called us, who was about to close on buying a house for a mortgage, called us in tears saying, the mortgage company won't make the loan now because I've got a judgment of $225,000 against me. What can you do? So they were that vindictive. What I said to John Deere's attorneys, we will fight you to the end of time if you try to collect this money against her. And we will hire PR people and talk about how you not only denied people their compensation, but then you went after them to the point where they would lose their house and their life savings, and they dropped it.
Wow.
So that's why people were scared.
Jerry, what you've been doing really is amazing. And the more we hear, the more compelling it is to recognize the role that you've played in helping to shape things up in the US. And because the financial services sector is truly global, there's absolutely no doubt in my mind that the positive impact that you've had on the fee structures in the US, driving competition through driving transparency, through driving accountability, that's not only helped pension savers in the US, it's obviously helped pension savers in other parts of the world, including the UK. So we have the title of this session. The session's title is litigation the pension saver's best friend? I'm becoming increasingly convinced that what Chris Toby told me many months ago is right. I really am realizing that when all is said and done, the kind of litigation that you've been able to bring forward has been more positive, more instrumental in driving out better outcomes for pension savers than the regulatory framework. So I'd like to reframe the question from is litigation the pension saver's best friend to I think Jerry Schlichter is the pension saver's best friend. And on that note, Jerry, I'd like to thank you so much for sharing with us your time. Robin used the word wisdom earlier. He said, Jerry, thank you for sharing with us your wisdom. And you have quite literally done that, and you have bucket loads of it to go around. Jerry, thank you very much. Can we please, I'm going to take everybody off mute, and I'd like us to please all take yourselves off mute and do what you can through Zoom to applaud as loudly as possible, or shake your hands, or do whatever you want to do to thank Jerry Schlichter for his presentation. Thank you very much indeed, sir. Thank you.
Thank you, Jerry.
Wonderful, wonderful, wonderful.
Keep up the good work, Andy, and all of you.
Thank you, Jerry. We're going to have a quick, just 10-minute break now, folks, a comfort break. So we'll reconvene at 25 past the hour. For those of you that wish to and want to reconvene, coming up, we've got Chris Toby, Robin Powell, George Melman, Philip Miller, Paul Secunda. I hope you've all found what we've covered so far to be interesting and engaging and meaningful. I most certainly have. And Jerry, thank you again very, very much indeed for what you've covered so far. Superb stuff. Thank you. Back at 25 past the hour, folks. Thanks very much. Thank you. Folks, it's just coming up to 25 past. So we'll be starting very shortly. We're going to go in the we're going to go in the order of Chris Toby, who has to leave at past, then Robin, then George Melman, then Philip Miller, Paul Secunda, Eric Smith, and that should leave us some time at the end for a general chit chat. Now, there are one or two people on the call who aren't in that list who I'd like to take the opportunity to very, very briefly introduce themselves. Bernd Hanke, can I go to you first of all, please? Please do take yourself off mute. Lovely to see you. It's been a while. Please, I think you're the token European living in the UK for today's session. So please briefly introduce yourself, and then we're going to go straight to Chris for his session. Thank you.
Yes, I'm involved in an asset management firm here in London, and I've actually also worked as an expert witness, actually for Jerry's firm. The EBB case that he mentioned before was one of the cases that I've been working on.
Thank you very much. I remember you mentioning that when we very first met at the meeting we both attended in London. I'm really pleased to see you with us, Bernd. Thank you very much for being here. Okay, let's now go straight to Chris Toby. So Chris has got a few minutes to share with us his key points. Chris, over to you, sir. And I invite you all to make sure that you're on speaker view. You'll know you're on speaker view if at the top right-hand side it says gallery view. Chris, over to you, sir. Thank you.
All right. Thanks, Andy. This has been great. Jerry is just remarkable what he's done, and I really just appreciate that. I'll give a little on my background. I spent my first 10 years in banks with retirement products, and I spent 7 years with Aegon Transamerica creating these, developing these products. So I know how the sausage is made. I know how the fees are hidden. That's kind of one of the things I bring into my consulting practice, which I do for both litigation and directly to plans. And so I've been involved in over 40 of these 401k fee cases, including one of Jerry and a few with Paul Secunda, who has actually done some great work as well. So again, as we've talked, and me and Andy, I've been convinced, I think we're all convinced now, that Schlichter has been one of those significant people in lowering fees globally. But the thing to remember is even in the US, this only applies to defined contribution plans, which are 401k type plans, and private plans. The plans that teachers have and public workers have are exempt, and so we still have very high fees in those areas. And I've been trying to get involved in some litigation around the public pension area, but the laws are much more difficult than they are for ERISA. Again, regulation, in my opinion, I think Jerry said this, has basically been a failure. They still have not brought any of these cases that I know of on the 401k fees to here, and they're pretty much captured by Wall Street, in my opinion. And as we speak, the Department of Labor is trying to weaken current fiduciary laws right now, especially when people roll out of their retirement plans into another product. So we do have that going on. So, most of these plans are still ongoing. Jerry was right about the attorney. Sometimes I'm not a lawyer, so it just floors me that one judge can see a good fiduciary breach and others cannot, and how the circuits of the different sections, and maybe some other people could talk to it, of the country in the US are better for bringing litigation than others. I think Boston's one of the best from what I've heard. Again, not a lawyer, but again, where these things come from. And then again, we are making a lot of history in the US as we're going kind of downstream. As Jerry has led the way with the biggest plans, we're starting to get some more regional plans. People like Paul Secunda and others are starting to get into what I call mid-size plans. A lot of hospitals, lots of kind of mid-size to larger employers. So we're working our way into more and more plans, but there's still thousands more in the US that are good for litigation. And again, that's part of my business, and I'm very encouraging of it. And it's really moving the needle here. And I'm hoping we can move to other countries as well. We have had a bet. In the U.S. Supreme Court just 5-4 decided against litigation and defined benefit plans on excessive fees. So that was a big loss just in the last month or two, called the Thole decision. 5-4, conservatives versus liberals said that you cannot bring litigation on the fact of excessive risk investments in a defined benefit plan. And this was immediately rolled over to a Kentucky Supreme Court decision in a case I'm directly involved in, involving Kentucky pensions. And I'm the author of a book called Kentucky Fried Pensions, and I've been involved in the public pension side as well. So all is not good, but Jerry Schlichter has really found the niche, found the one place where we can get some justice in the United States, and has run with it at considerable expense to himself. So I want to end by thanking Jerry for his groundbreaking work that has created opportunities for a lot of people, and have really helped reduce fees around the U.S. Thanks.
Chris, thank you so much. I know that you've got to shoot very, very shortly. I'm going to ask you one question, okay? I know that you've had to kind of street fight your way to justice over the years. I know that from the many conversations we've had. And it would seem to me that there are parts of the system, I'm not suggesting all of it, I'm not even suggesting much of it, but it seems to me that there are parts of the system that, for want of a better word, are basically riddled with corruption and fraud in the private equity kind of space. Would you like to just briefly comment about your thoughts about that comment?
So corruption prevails in a lot of places. Jerry got over the conflicts of interest of wine and dine, things like that. But again, we have banks. A lot of the corporations use the bank for their own financing. You'll see conflicts of interest with banks, with them using that. You'll see conflicts of interest in the other areas, the self-dealing type of issues. But what I've found in the public pension world is that we've seen a lot of what we call private equity and hedge funds that, as so far, the good ERISA laws have prevented from going into our space, at least to the 401k space. But in the public pension world, we have the most secretive, worst, highest fee investments dominating the private equity and hedge funds. And I believe a lot of that has to do with what we call in the United States dark money political contributions. We had a decision 8 years ago now, Citizens United, which allows unlimited what we call dark money secret contributions to state level politicians. And I think that has affected a lot of allowing and it blocked a lot of the transparency on the public pension level. So that's something that I'm working very hard with. Now, I've been very successful in actually making some money on the 401k side where Jerry is and where Paul is, but on the public pension side, it's been a lot of pro bono work, and I've done thousands of hours on that side that have not been compensated yet. But it's good that there's at least one area we've got in the 401k world where we get some justice and things can go that way.
Chris, thank you again. I've put a link to Chris's book, Kentucky Fried Pensions, into the chat. I highly recommend it for anybody that's serious about looking at the dark side for corruption and cultural flaws in the system. Chris, thank you very much indeed. Can we all wave our appreciation to Chris? I think he has to get going soon. Thank you very, very much indeed. Okay, thanks, Chris. Superb input. Okay, I'm going to invite one or two people who aren't on the list of speakers to briefly introduce themselves. So could I invite Sunil Chadha, Siobhan Redding, if she's with us, and George Melman. Forgive me, George is speaking later. Also Alex Varley-Winter to take themselves off mute, and also Neil Scarf to very, very quickly introduce themselves. So Sunil, I think you're now off mute. I know the topic is of huge interest to you. Could you please briefly introduce yourself and tell everybody a bit about why it's of interest to you? Thank you.
Yeah, sure. Well, I'm a TTF ambassador. I sit on the advisory board of the APFI, and I'm a project director at Punter Southall Analytics, so I wear many different hats. I've been concerned about financial services for quite a while, and have to say it's reached a point where the only way, for me, it's part of a proper functioning market, you've got to have litigation, right? It's part of a proper functioning market, and that's where I'm working. I'm the architect of a few cases in the London market, and I'm very keen, and I take my hat off to the people on here tonight. It's fantastic.
Thanks, Sona. Lovely. I invite you and everybody else, absolutely everybody, to put your contact details, for example, your email address or your LinkedIn profile, into the chat. One of the benefits of these sessions is that we can connect effectively and we can network. So Sonal and everybody else, please feel free to pop your contact details into the chat and we'll circulate those. I'm going to hopefully we might have Siobhan Riding with us, who might want to introduce herself. Siobhan, hi, lovely to have you with us. Please tell everybody a little bit about you and what you do. Thank you, Siobhan.
So yeah, I'm a journalist at FTFM at the Financial Times. So I cover fund management. I've been covering some of the rollout of the FCA value assessment rules, and that's sort of what led me to this discussion. So I'm just listening out of curiosity to kind of get the US perspective and see how this debate is evolving in the UK.
Thank you very much indeed for saying hi. Let's now go to, and it's lovely that you're with us, Siobhan, thank you. And let's now go to my colleague, Alex Varley-Winter, who's with us this evening as well. Alex has got a very, very special role within the Transparency Task Force community. Alex, please tell everybody a bit about yourself and what you're doing with us. Thank you.
So I'm an investigative journalist. I run a blog for TTF. I do some freelance work, and I'm a fairly new parent, so it's very much kind of part-time for me at the moment. But yeah, I'm interested in the subject. I'm not really an expert on pension schemes or anything like that, but I have over the years observed quite a lot of opacity around costs, especially unjust costs in courts, and lack of scrutiny, lack of regulation, just a huge void there, and see some similarities between those experiences. So yeah, mostly listening out of curiosity, but also with that kind of struck a chord with me. Also, I was very intrigued to hear that you used effectively no-win, no-fee agreements to get justice in the States, because I'm aware of sort of no-win, no-fee abuses in the UK where they pretended it was a no-win, no-fee agreement, but actually had hidden fees that eventually went back to bite the litigants. So it was kind of interesting. All right, thanks.
Thank you, Alex. I think you might be referring to the Heather French case, perhaps, when you make that point in particular. Thank you, Alex. Lovely. Okay, let's now go straight to, we're going to go straight to our next speaker, who's going to be Mr. Robin Powell. So, Robin, please unmute yourself and tell everybody a bit about your background and how you got into the space in the first place, because I think you made a very, very unusual step from one background to another to make this transition. Robin, tell us about yourself. Thank you.
Yeah, I'm a journalist, and I have been a journalist for many, many years. Mainly worked in television. Thought I knew a lot about investing. Actually, didn't. I made a documentary about 8 years ago called "Passive Investing: The Evidence." So I've since made several other documentaries, and. As a journalist, I was just shocked that there's all this information out there about how people should be investing to get the very best outcomes, but how not only do the majority of investors not do that, but they're actively encouraged by the industry not to do the right thing, if you like. So I now pretty well work on this full time.
Thank you, Robin. And your thoughts, please. Please tell us what you'd like to say about this general topic of litigation to get justice and fees and charges and so on. What would you like to share?
So is litigation a pension saver's best friend? I mean, I would say that pension savers have to become their own best friend. We can't expect asset managers to do the right thing. It's just not realistic. Managing other people's money is extremely lucrative, and it's easy for fund houses to make it look as though they're adding more value than they actually are. They're only human, and if they can get away with it, they will. And who's to say that if we were in the same situation, we wouldn't do exactly the same? Legislators sadly can't be trusted either. They have their own vested interests. They need to keep the industry on side for one thing, and the industry, as we know, is hugely powerful and persuasive. Chris was talking about the regulatory capture in the US. That's a very strong phrase to use, but I think it's accurate, and it's accurate, sadly, here in the UK and in continental Europe too. I'd like to think that advisors are a saver's best friend, but my experience over the last few years is that there's a depressing lack of interest among financial advisors generally about issues around transparency and fees in particular. Part of the problem is that those very advisors, and particularly investment consultants, have been complicit, if you like, whether knowingly or not, in this transfer of assets from consumers to investment professionals. I agree with you, Andy. If there's a lever that can be used to help the little guy, we should welcome it. I think the litigation that we've seen in the US to an extent will come to the UK. We know there are various class actions regarding Neil Woodford coming up. I expect at least one of those class actions to be successful. I think that really will be a watershed moment. But for me, litigation has to be a last line of defense. The first line of defense has to be self-education. I've been greatly inspired over the years by William Bernstein, the US author, and he says in the 4 Pillars of Investing, investors have to remember that they're engaged in a life and death struggle with the financial services industry. Every dollar in fees, expenses, and spreads you pay comes directly out of your pocket. So ultimately, I think it's up to investors to wise up, to read blogs like The Evidence-Based Investor, to read papers that are aware of these issues, and alas, you know, there aren't very many. The FT and the Sunday Times, I'm not just saying this because I know Siobhan Riding is on the call. We heard from Alex as well, your own investigative journalist at the task force. We need more investigative journalism, frankly, in the asset management industry. And finally, we need to learn in particular about the importance of cost in long-term investment outcomes. And as Warren Buffett himself has said, investors big and small should stick to low-cost index funds, full stop.
Yeah. Robin, thank you so much. There's a lot of passionate knowledge stored within the comments that you've made, and I know that you are determined to help make sure that people go investing money cognizant of the importance of the costs and charges element. You're doing an amazing job with your blog and with the communications that you put out. Robin, I do encourage you, please do put a link to the Evidence-Based Investor into the chat, because there may be 1 or 2 people on the call who don't know it yet and may want to subscribe. I invite you to do that. Thank you very much indeed, Robin. We're now going to go to George Melman, and I'm hoping that after we finished our round of quick thoughts from various folks, we're going to have time to talk about Woodford, because I agree with Robin. I think Woodford could be a watershed case in the UK's treatment of these sorts of issues. So George Melman, can you please take yourself off mute, introduce yourself, and share with us your thoughts. You need to click off mute. Lovely, go for it please, George.
Yes, thank you, Andy, and certainly Jerry is a hero for all the reasons that other people have said. By background, I'm a trained investment analyst. I also spent a good chunk of my career as a an independent investment consultant, and also an investment consultant who was affiliated with a large financial services company. I was often in the room with these financial fiduciary committees. I saw how they do it, and I will echo, I think, what's been said a little bit. Certainly in the early years, it was more of errors of omission than of commission. And Jerry alluded to this is important, that really, in the US anyway, the 401k industry started out as a offshoot of really human relations benefits. It was a benefit add-on for employees. And truthfully, human resources are not prepared. Typically, they viewed it as somewhat like payroll processing. And I think as long as firms like Jerry's were not successful, or no one was successful critiquing the system that had been set up until about 15 years ago, and Jerry got involved, then I think that HR people were fine, just easy taking as it is. But that of course all changed. But I just want to make a point that it really was an omission than commission, and we all, I think, know that investment management and investment compliance are in fact very, very complicated. And so that had to change. And fortunately it is. I do want to mention a few other areas that frankly have benefited Jerry and benefited all of us. First of all, the original retirement plan 401k legislation called ERISA here in the States, enacted in 1974 and managed, overseen by the Department of Labor. It does clearly say that the interests of the employees are number one. And that is a clear advantage. And without that kind of language, there's no way that Jerry's firm would necessarily be successful, and we'd be talking about the same problems and not knowing what could be done. And I also just want to say it's not assumed that that's going to be the way in the future. It's certainly, there's nothing that could prevent a future Department of Labor or a future Congress for amending that. And certainly in other types of retirement accounts here in the States, I'm talking primarily about individual retirement accounts, they don't have that high level of fiduciary satisfaction. Secondly, I want to say that as much as this is an important benefit for employees, plan participants, I think one of the other things that happened about 15 years ago was that, in fact, this Department of Labor that we want to criticize so much, they did approve the default option for retirement plans to be really diverse, target date, age-based, diversified funds as an appropriate default action. And that really was important. And as much as other people might want to say that investors want to take control, need to take control of their investments, the truth is, and I know this because I worked with firms that do provide these retirement services, that 80 to 90% of all employees across the US do not do anything with their 401k investments. It comes in, they don't know what to do. So actually moving it from a very low restricted money market or stable value fund to a more diversified age-based target date fund was a huge innovation. And in my view, in truth, it's benefited employees much more than any of the fee-based reductions. I'm not taking anything away from it. It's just, let's keep some things in perspective. A third point that I would like to make is that the tax advantages of employee retirement plans. There are tax advantages, and there is some discussion among some people in the US legislature to potentially change that. It's become a little bit of a campaign issue, and there's a bit of an issue of how is this huge COVID-related deficit going to be funded. And one of the topics that's come up is removing some aspects of the tax advantage. That would be awful for retirement savings and for the benefits to employees. And another aspect, and Jerry did allude to this, one reason he's been able to be successful is he's able to get class certification, a class action suit. He can afford, as he says, the 8-digit line of credit. Class action, he goes after the big companies because, frankly, he needs to cover his costs. But you couldn't do that without class action certification, and indeed many other areas of the investment community here in the United States, including, again, individual retirement accounts. They don't allow class certification, and that's been to the detriment. And again, there's no reason why class certification should be assumed in the future also. And the final point I guess I want to make is that one of the things that's happened with the litigation, it may be good, may not be good, is that it's been part of the entire emphasis and steamrolling of passive low-cost index funds. Many of us think that that's really an advantage, that the low-cost index funds are really best for most individuals. But many other people in the investment community would say that, in fact, perhaps some employees and some other investors are not being served well by the lowest cost investment firms. From a fiduciary committee's point of view, they want to avoid litigation. I think, at this point. The tendency, from their point of view, is let's just put index funds in there, low cost, we're not going to be sued. And so I want to bring that up as a potential future topic, is to say, is there a little bit of a negative with all this litigation? That might be it. I understand the counter arguments thoroughly, but active management can have advantages. And from the point of view of a fiduciary committee that wants to avoid litigation issues, they need to stay away. Okay.
George, thank you very, very much indeed. Thank you for your thoughts. One of the lovely things about the community we're building internationally is we create this large, friendly place where everyone can say what they think. And we often have people who have very different points of view. And I think there may be a bit of a contrast, for example, in some of your views and some of Philip's in relation to things like index tracking and passive investing, etc. George, thank you very much indeed. Can I invite Philip Miller to please unmute and share with us what he'd like to say? Thank you, Philip.
Thank you, Andy. Well, as I said before, I'm co-founder of Fair Return. We help people, retail investors, get what they're owed for unsuitable pension transfer advice, mainly. I'm also an ambassador for the Transparency Task Force and proud to be one. I would say that litigation could well be the pension saver's best friend. Some other potential best friends are governments, who can make new laws, regulators who can make and enforce rules regarding, for example, the suitability of advice or costs disclosure, pension plan sponsors who can be prudent in who they choose to advise on, administer and manage their employees' pensions, or even financial intermediaries who might voluntarily decide to do what's in the saver's best interests. I think most would agree, however, that these groups have, generally speaking, not been very saver-friendly to date. A notable exception worth mentioning here is Vanguard. Its very structure, put in place by one of my heroes, Jack Bogle, is inherently saver-friendly, and as a result, fund costs proven to be the most important factor in future returns and the only factor with reliable predictive value when it comes to future returns have fallen consistently over the years. Financial intermediaries, the businesses involved in administering, managing and advising on the pension savings of others, are, like other businesses, driven by the profit motive. They want to make more money year after year. There are basically two ways to increase profits. You can increase revenues and you can reduce costs. When costs increase, profits fall and can turn into losses. The PPI mis-selling scandal in the UK is a stark recent example of this. An amount approaching £40 billion has been paid in compensation in the last 10 years or so, most of it by the major banks. Lloyds Banking Group alone accounts for about half of the total amount. In many of the 40 quarterly earnings reports of the last 10 years, Lloyds has reported either a drastically reduced profit or even a loss as a result of PPI-related provisions. The share price and level of dividends has fallen accordingly, and management and staff bonuses have been cut in a big way. I think it's fair to say that in the future, Lloyds will not only be focusing on what and how much it can sell, it will also be thinking very carefully about what potential compensation costs it needs to avoid. There are two main motivators when it comes to what drives the behavior of financial intermediaries: greed and fear. Greed is powerful, but fear is even more powerful, and it's more contagious. What's more, the fear of losing what you already have is more powerful than the desire to gain what you don't already have. Thanks to the work of Jerry and his firm and others, more and more people are realizing that when they haven't been treated properly by the advisor or financial intermediaries responsible for looking after their retirement savings, they could do something about it. There will be billions more pounds, dollars and euros of pension compensation paid out in the coming years. At the same time, financial intermediaries' attention will turn slowly but surely from how to make as much money as possible to how to avoid losing large sums as a result of litigation. The fear factor may well, for a time, replace the greed factor as the dominant force. From the saver's point of view, another reason why litigation may be a best friend is because it can add a substantial sum all at once to a saver's pension pot. This can then be invested sensibly to compound throughout the remainder of a saver's accumulation and decumulation periods. Accordingly, a £100,000 compensation payment at, say, 50 years of age can result in several £100,000 more extra retirement income. Good evidence-based investment advice and management is undoubtedly important, but it is easily overlooked that a lump sum compensation payment can have the same positive impact on retirement income as many years of good advice and management. So to conclude, I've been following the work of Schlichter, Bogard and Denton for a fair few years now, and I think Jerry and his firm deserve enormous credit for what they've done in the US and in recent years. And it's going to be interesting to see how litigators in the UK and other countries follow their lead. Thank you.
Wonderful. Thank you very much indeed for some extremely thoughtful points there. Wonderful. I see we have Stuart Frank's hand up. Stuart, lovely to have you with us. Please do introduce yourself, make your point, and then we'll go straight to Mr. Paul Secunda, followed by Eric Smith. Stuart, far away. Thank you.
Thank you. Can everybody hear me? I'm not sure if my
Yeah, we can hear you. We can
hear you. Okay, good. My name is Stuart Frank. I've been very active in the area of fiduciary compliance, and my touch point is through the American Institute of Certified Public Accountants. I'm the designated subject matter expert for the AICPA's personal financial planning section, and I've served in that capacity for the past year or so. I was the lead consultant on a review of fiduciary compliance materials that was undertaken by the AICPA, and so I come to this from not so much from the litigant point of view, but from the fiduciary compliance point of view. And I would like to say, compliment Jerry for something that he didn't talk about that has enormous, I think, factor here in the U.S. One of the decisions that he got at the Supreme Court level, that he referred to it, the 9-0 decision that he got. One of the issues that he was litigating took so long to litigate that it was beyond the statute of limitations. ERISA has a 6-year statute of limitations, and one of the breaches that they were litigating occurred beyond that 6-year statute. And so the issue went all the way up to the Supreme Court as to when the statute of limitations ran. And this was the 9-0 decision that resulted from that. And the court said that a fiduciary breach in the statute of limitations does not begin to toll until the breach has been addressed. The area of the breach has been addressed. And that has huge implications going forward, because many of the claims that are going to be brought are well beyond the 6 years. But if the fiduciaries have not, presumably if the fiduciaries have not addressed that issue in the interim at all, the statute of limitations does not begin to toll. And theoretically, the fiduciaries are personally liable from the beginning of time till the judgment is rendered. And that opens up the litigation door wall, if you will, to many, many additional claims. The other thing that I'm very interested in is kind of the mirror image of the fees. There's a well-known concept in modern portfolio theory of the value of the diversification brings to a portfolio. It's been estimated by Eugene Fama and David French to be in a broadly based equity portfolio anywhere from 100 to 150 basis points a year of added return that can be extracted from a well-diversified portfolio versus one that is not well-diversified. And many advisors go and represent that they're giving their clients well-diversified portfolios, when in fact they're not. And it's going to be very interesting to see where this litigation leads to, because in the U.S. that they're making a false claim. It's considered investment fraud to make a claim that you're doing something when in fact you're not. And that is the thrust of my business interest, which I had a firm called Precision Fiduciary Analytics, and we use high-level analytics to analyze how well diversified a fund is and provide recommendations for where it can be improved. And George, I listened with great interest to your comments, because the diversification factor is what adds value to having not just the low cost index funds. It's by having value and all its progeny interplay with an index fund that gives the extra diversification value that can be brought to an investment portfolio. So,
Stuart, thank you very much indeed. Until I first heard you speak about the significance of portfolio diversification, I had a complete blind spot to the relevance of it, to the extent to which you have. And I really do appreciate you having opened my mind up to this issue many months ago. And frankly, I think many other people are as blind to the significance of portfolio diversification now as I was a few months ago. So I really welcome you raising this point. I encourage all of you to take a look at Stuart's work, because it's compelling stuff. It is very, very compelling stuff. Stuart, I encourage you to put your contact details into the chat. So if folks want to connect with you, they may be able to.
How do I do that?
I'll tell you what we'll do. With your permission, my colleague Alexandra will put your email address into the chat. Is that okay?
That's perfect. Yes.
Okay, Alexandra, if you can take care of that, please, Stuart. Thank you. That's good. We're now going to go to Mr. Paul Secunda, who I have to tell you is, I think, one of the oldest supporters of the TTF. And Paul used to help me get through the tough times in the early days. And the amount of conversations we'd have where it'll be just me and Paul keeping each other just about sane. So I'm really pleased you're with us tonight, Paul. And I'm also very, very pleased that things are going so well for you with what you're now doing. So tell everybody about that, Paul. Thank you.
Thank you, Andy. Well, I'm so happy that you are in the gravy days now a little bit, and that things are going better. I had no doubt they would. I know it just take a little bit of time. So it's wonderful to see how well things are going. And listening to Jerry today, it was very interesting. I used to follow him as a law professor back in 2005, 2006. And then I recently left the academy to become a practitioner. And as Jerry and others have mentioned, I have filed about a dozen of these cases, mostly in Wisconsin, which is where I am, and mostly with slightly smaller companies than Jerry's. Jerry's in the multi-billion-dollar range. Most of my suits involve plans from 200 million to 800 million, which is not small, but in comparison, it's a little bit smaller. Let me just make a few observations, three in particular. First, I thought it was very interesting what Jerry said about finding plaintiffs. We often say in the plaintiffs bar here in the United States that plaintiffs are really the currency of what we do. If you don't have a plaintiff, you don't have a lawsuit. So how do you find a plaintiff without violating our anti-solicitation rules, which are very strict as far as advertising and going out and getting plaintiffs? Well, what we've done at my firm, Olszewski and Luzzi, is we have taken advantage of the fact that we are a full service labor and employment firm. In other words, we do all sorts of workplace cases. We do discrimination, we do retaliation, we do wage and hour, overtime, hours, bonuses. We do all sorts of different benefit cases, not just retirement, but health care and disability. And so what we do increasingly is when we have a client, we'll say to them, hey, by the way, let us look at your 401k plan. We'll do kind of a due diligence to see if everything's okay there, along with all the other things that you're upset about. And, you know, a lot, not always, I mean, some of these plans are in good shape, but a lot of them aren't. And so by looking at public information, there are 5,500 forms, financial disclosures. We have other types of participant disclosures called 404A5s, where you have to told not only what the investment options are, but what fees are associated with those options, record keepers, what their fees are, day-to-day administration. We're able to find a lot of information. And as I was explaining to someone here in the United States who did an article in Bloomberg about a week ago about all the recent cases, I feel like we have become more sophisticated in the plaintiff's bar. We have more information. We know how to get the information. We know how to use that information to meet legal standards that are increasingly being applied by judges. And there are different levels of difficulty depending on where you are in the United States. That's point number two. Being successful in a case in Minnesota or Missouri, St. Louis or Kansas City, where Jerry is different, to be frank, than being successful where I am in Wisconsin, which includes Illinois and Indiana, which is our 7th Circuit. The law is much more difficult. It's just come out that way. One of the first cases Jerry lost, the Deere case, was in the 7th Circuit, Hecker versus Deere. So we have a few more obstacles to overcome, but nevertheless, we feel very good about the types of cases we are bringing. We believe that litigation is the pension saver's best friend because, unfortunately, more conciliatory ways of going about and getting people to treat you fairly has not worked. The government has not been as aggressive as I think they need to be in this area. And so the litigation that Jerry pioneered and that I and others are now following up on are really what I would say hitting a second phase. So this article that I just referred to in Bloomberg pointed out that in the first 8 months of 2020, there were 65 lawsuits filed in the United States alleging some form of excessive fee or imprudent investment within a 401k or its counterpart, the 403b, which is for nonprofits. Of those 65, we filed 10. Jerry's firm filed 5. Another firm called Nichols Castard filed 5. And then there's a firm that's filing a lot of them called Capozzi and Adler, which has filed 25. So about 5 of us are filing, 60, 70% of the cases right now. So it's a specialty practice. It requires a good amount of sophistication. And the third point I'll bring up is the defenses have become a little bit more sophisticated. Just as the plaintiff's bar has gotten better, I think the defense has also grown in light of Tibble and the other cases that were decided. So for instance, as someone just mentioned, we just had a decision in 2020 in June called THOLE, T-H-O-L-E, which made it more difficult for those who want to hold defined benefit plans accountable to bring cases. We call it in our country standing or constitutional standing, which is under Article 3 of our Constitution. It essentially means you have to have a particularized injury, has to be redressable. So you can't bring a premature case. You can't bring a case that's not ripe, where you don't have an injury that's involved. We believe on the plaintiff's bar that case does not apply to the defined contribution plans, the 401k plans, because when you sue like Jerry has and I have, you're not suing as an individual, you're essentially suing on behalf of the plan. You're suing to get money back to restore the plan to where it should have been if there hadn't been a fiduciary breach in the first place. So we believe we'll be successfully able to fight off those standing arguments. But the reason I bring it up is just to show you that just as we are not staying pat as far as our own arguments, nor is the defense bar. This is an evolving situation. And I gather that as we continue to file more and more lawsuits, which I will, we will be able to push record keeping fees lower, but we'll also continue to have intransients and people who would rather pay those fees and legal costs and fight us. And we're in it for the long term, so we're ready for it. So thanks for having me, Andy. I appreciate it.
Thank you. very much indeed. Thank you very much indeed for sharing your thoughts, Paul. It really is lovely to have you with us. We're now going to go to Mr. Eric Smith. So, Eric, your thoughts. We're going to finish at 1:30, folks. 1:30, and I'm hoping for at least a little bit of the time after Eric speaks, we're going to be able to talk about Woodford, because I think that is going to be the catalyst for potentially quite a bit of change in the UK market. Eric, please share with us once again your thoughts, please. Thank you.
Well, thank you, Andy. I think this has been great. I want to play off a couple of the earlier remarks, one of which is what Paul just said about the 65 cases. If you make a fraction out of that and divide it by 600,000 cases, you get an idea of essentially how effective litigation is as an agent of change at this point. I agree, litigation right now is the only thing that effectively is changing anything, but I want to go then to Robin's point, which is that everybody is on their own. That this is about self-education, but it's not just about self-education, because here's the real key problem, both for investment consultants, and George, this is for you. There are 30,000 mutual funds in the US in share classes. So there are too many choices and too much information. So even the most sophisticated investment consultants are overwhelmed and are dealing with heuristics. You know, they pick fund families, they do this sort of things to try to pick something reasonably good. But at the end of the day, for individuals, Robin, they can know everything about it, and they wind up defaulting to index funds and low-cost funds, principally because the odds of finding an active advisor out there, as the various publications say, are sometimes as bad as 8 to 1 or 9 to 1 against finding a superior active manager in comparison with passive. So we've been focused on, in my world, focused on empowering individual investors to be able to comparatively evaluate choices for themselves. Paul, that would then go to you in your world, because if individuals can comparatively evaluate choices for themselves, they can self-identify as potential plaintiffs and find you, and find Jerry, and find others, and find Paul, you know, to represent them to correct the wrongs. Interestingly, the whole idea about the closet indexing winds up being worst in defined benefit plans, Paul, for one reason, and that is in the investment policy statements, the standard by which people have to perform, investment have to perform, is so abysmally low that if you're beating the index by any amount, no measure of volatility, no measure of risk, you can keep your job. So the hardest thing in the institutional world is to get employed. And so if you get employed and the bar to stay employed is that low, why would you take a chance at superior performance when you can closet index and keep the position? So this is institutionally built into the thing. Yeah. So as we've been trying to introduce different changes, something that would fundamentally change the situation and the power structure other than litigation, we found a remarkable resistance from the industry to change the status quo. Plus, the education of trustees is such that they have no alternative but to rely on the advice typically of single investment consultants. So in dealing with one of the lawyers who represents a lot of the big pension plans, Taft-Hartley plans on the East Coast, on the labor side, you know, we were discussing Tibble versus Edison and all of the impacts of this. He actually said something to me that I was surprised. I never thought I would hear from a lawyer representing the labor side of the equation on this. He said, you know what, Eric? He said, the bottom line is that there's not enough trustees being sued. So You know, so let me finish with that and say my endorsement to all of you guys that are out there trying to do this. Paul, the two Pauls, Jerry, everybody, you know, I think you're doing a tremendous service, but we're looking to try to do something beyond that because the leverage just really isn't there with regard to the numbers.
Thank you very much indeed, Eric. Great stuff, absolutely great stuff. I do encourage you all to take a look at what Eric and his colleagues are doing with his analytics. It's mind-opening stuff. It really is. Okay, we've covered off the organised short speaking slots. Thank you all very much indeed. So thank you, Chris, Robin, George, Philip, Paul, and now Eric. We've got about 10 minutes or so what we call fireside chat. So it's pretty much, you know, unscripted territory here. We can go anywhere, but I'll tell you where I want to start. I really would like to start talking about the Woodford case. Now, we have a few folks on the session tonight who are from the other side of the Atlantic, so may not know the Woodford case. And I'm going to invite Robin, if he doesn't mind, just to kind of give a little bit of an overview of what actually happened in Woodford and to share his thoughts about what the potential justice points are. You know, how have people lost out and what happened? So Robin, I know this has been a big story over here in the UK. What are your thoughts, please, about the key points about the Woodford case? And we'll go from there. Thank you.
Well, you know, anyone who follows active management and the fund industry will know that all the time we hear about managers who, you know, look like the genius a few years ago, who have really come a cropper and lost their clients a lot of money. Their funds are closed or merged with another fund, and their performance, their dreadful performance, conveniently, you know, swept under the carpet. But Neil Woodford was on a completely different level. Here was a guy who had a lot of success at a firm called, you obviously know of Invesco Perpetual, and he performed well over a number of years. For those who stuck with him, and of course there's always a question of, you know, whether people can actually spot these people in advance, but there's no doubt that for some of his investors, he did very well. He then set up on his own, and he set up, in particular, an equity income fund in June 2014, which was launched to a massive fanfare, huge promotion in pretty much all of the newspapers. And he was treated like an absolute megastar. And gradually over the years, we sort of came to realize that he actually wasn't producing the kind of performance that investors thought they were paying for. And lo and behold, in June last year, a crisis developed when Kent County Council, which had invested heavily in him, wanted to get its money out, and the fund wasn't able to sort of pay up, and as a result, the fund was gated. And ever since then, investors have had their money trapped in there. They have been receiving money in drips and drabs, but it's nowhere near what they put in. Of course, remembering that those 5 years that Woodford was managing their money were pretty stellar years for the stock market. So the situation we're at now is there are, I believe, 3 different class actions, and they're all different in nature because they're all aimed at different sort of parties involved. One of the guilty players, certainly as far as I'm concerned, is Hargreaves Lansdown, which is a platform which heavily promoted Woodford, and for all intents and purposes advised, although, you know, strictly speaking, they would say they didn't advise people to invest in Woodford. There's another, at least one class action against Link Fund Solutions, the firm that managed the fund and didn't spot there are quite serious problems with unquoted stocks and so on within the fund until, well, I say until the last minute. It actually remained on certainly Hargreaves Lansdown's recommended fund list until the moment that the fund was gated. So there are a number of issues here against Hargreaves, against Link Fund Solutions, and as far as I'm concerned, against those many financial advisors who recommended Neil Woodford.
Thank you, Robin, very much for providing that that excellent overview. That really was excellent. Thank you. Okay, folks, we have roughly 10 minutes or so of Fireside Chat left. Would anybody like to share some further thoughts about the Woodford situation, or indeed anything else that is somehow relevant to this evening? Of course, I'm particularly keen that we hear from anybody who hasn't had much of a chance to say anything so far this evening. I'm going to check in with Vanilla. Vanilla, if you can, would you like to unmute yourself and perhaps introduce yourself and share any thoughts that you've got? And also Neil Scarth, if Neil is there behind the screen, as it were, whether Neil would like to share some thoughts too. Vanilla or Neil, are you with us? I think they might be out making a cup of tea by the looks of it. Okay, in which case, we'll go to anybody else. Paul, Mr. Paul Bates, go for it, sir.
The law is full of procedure, and the UK does not welcome class actions. They have, as many of you will know, a group action method in which there are many difficulties getting stakeholders to sign up to participate in the claims, and the funding required to undertake those actions has multiples which require a great many such stakeholders to agree to participate before it becomes economically viable for the funder to bring it on. So it's the opposite of the United States, where you have one representative, and if the claim, same as Canada, if the claim is sensible as pleaded, it can be undertaken. So the access to justice problem in the UK is severe, and I was dismayed at seeing firsthand, working somewhat in London, how bad it is. In Canada, it varies by geography. Ontario, where I live, has also adverse cost exposure and great hindrances, but British Columbia and Quebec do not. So the geography is making a big difference up here. There's a way to get around it in the UK with something called a representative action, but the courts have there said that the stakeholders have to have no individual issues concerning causation and loss in order for such a representative claim to be pursued. So I find it dismaying. I think it's going to change eventually. The British public won't put up with scandals like you're discussing here with Woodsford for long. And the problem is those involved in the UK Shareholders Association will understand entire individual retail investors, whether in their own funds or through pensions, have difficulty getting redress. The entire securities litigation regime works for big institutional investors, and in my view, not at all for retail investors. I'd like to work on that in the moments that career permit. So it's wonderful to chat with you all. I'm afraid I must sign off, and it's delightful as always to hear your moderation of these wonderful calls. I hope I've been in court so much. I think I worked the whole summer, but there'll be soon opportunities to catch up to you with you, Andy, and look forward to speaking to the rest of you soon.
Thank you, Paul. Thanks very much indeed. Thank you. Wonderful. Okay, we can wrap it up now, or if there's anything else that anybody else would like to share, please just raise your hand or shake your fist or stick your thumb up. Eric Smith, go for it, sir. Thank you.
I was a little bit confused about the Woodford case and whether it was what the scandal was. Is it like a Bernard Madoff where somebody was?
No, it was more like basically it was misrepresentation. That's the word that comes to my mind, in the sense that he was describing the fund in a manner where it appeared to be quite liquid and quite safe, but in reality it wasn't. There was what we call, I think the phrase some guys use is style drift. You know, what was originally on the prospectus is actually not what ended up being the reality. So people quite rightly thought they bought X, but they actually bought Y. There's some big questions around the marketing literature. There's an even bigger question, Eric, around the process that the regulators use to sign off financial advertising. In the UK, all advertising is run by and regulated by the Advertising Standards Authority, that has very strict, well-established protocols about what you can and can't do, what is and what isn't misleading. The difference is financial services. Financial services comes under the financial regulators. Let's just put it this way, growing concern about the efficacy of the regulator's job in making sure that people do not get misled accidentally or otherwise by unduly exaggerative, if that's such a word, advertising. Robin, I see you nodding on that. Would you like to just comment any further in relation to that particular point? You're on mute, Robin. There we go.
So sorry. So in answer to that question, no, there wasn't any suggestion that he was doing anything of the kind that sort of Bernie Madoff was doing. It wasn't a pyramid scheme or anything. It was just a very badly managed fund, particularly from someone who got such a stellar reputation for managing other people's money. This style drift thing is a real issue with the active fund industry. You buy something which at the moment looks like a large cap equity fund, but over time a large cap equity fund could branch out into sort of mid caps, into small caps, even unquoted stocks. And as we all know, active managers do dip their toe in other asset classes as well, like cash and for liquidity reasons and bonds and so on. You often don't know what you're getting, and as Andy says, the impression they were given was that they were getting something which was a solid, sound investment, but actually, as it turned out, was anything but.
That makes it much clearer. It sounds like that's straying into Stuart's bailiwick on whether or not something is straying outside of the area in which they should be playing. So thank you very much for the clarification. That wasn't clear to me initially.
Very good. Thank you very much. Okay, folks, I propose that we look to bring the session to a close. I can honestly say that it's very rare that you have a session which is essentially about a man's work, the lifetime work of an individual. But I think we've been able to celebrate that quite literally this evening with the work of Jerry Schlichter. And it's also wonderful that many of his kind of followers, disciples have also been with us today. Paul Secunda, Paul Bates, obviously Eric's involved in this space too, and various other folks as well. So I'll close by simply saying that I'd like to thank you all very much indeed for your ongoing engagement and support with the Transparency Task Force, for your contributions this evening, which have been wonderful. And we're very busy. We're always out looking for topics we can cover. We never seem to run out of ideas because we never seem to run out of chances to meet lovely people. So we'll say cheerio and good night, and thank you all very much indeed. Cheers, Paul Secunda. Thanks, Stuart. Thanks, Robin. Thanks, Alex. Thanks, Neil. Thanks, George. Thanks, everybody. Cheerio. Good night. Thank you. Bravo. Bravo. Very, very good. Cheers, folks. I love seeing smiley faces. I really do. It's lovely. Thank you. Good night, folks.